Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And while I recently had the opportunity to talk to the folks at Serenade about their case management system, e-Immigration, they've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI Workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Beginning of the year, and lots of roundup to do at the top of the episode this week. First, the Supreme Court justices vacated and remanded Santana v. Garland from episode 197. Back to the Fourth Circuit it goes, post-Loper Bright. Santana was a bit of a crazy Fourth Circuit decision that said that in a deportation or removal proceeding where someone is seeking adjustment of status, the applicant has the burden under a, quote, clearly and beyond a doubt, end quote, standard, not a preponderance of the evidence, to establish admissibility. Kinda wild and not how I understood the precedent at the time, and well, now it's going back. Also this week, a split Ninth Circuit panel affirmed a district court judge judgment in favor of a class of immigration detainees at a GEO Group facility in Washington state, which by the way resulted in like a $24 million judgment against GEO for using immigrant labor to essentially sustain their detention facility, paying the non-citizens $1 to $5 a day for their labor, which is well below Washington minimum wage. To quote Ira, quote, "This is the most important immigration decision this month. Everyone should be suing GEO," end quote. Noted. That's Nawazor et al. V. GEO Group, by the way, for those considering copycat lawsuits. Sticking with the Ninth Circuit, on Friday, the court vacated its quite non-citizen-friendly Kumar v. Garland decision from episode 223, and then issued a new, non-precedential decision. Let's sigh. Still a remand, though. Also, and finally, just for the pre-episode preview cases, in a detailed, unpublished 10th Circuit decision this week, the court remanded an ineffective assistance of counsel-based motion to reopen denial, stating, among other things, that, quote, although the BIA has consistently required the filing of a bar complaint to comply with the third Lozada requirement, it has not established what evidence, if any, must be provided to satisfy this requirement. The Lozada decision itself simply states that the motion to reopen should reflect whether a complaint has been filed, end quote. That is, the BIA can't just deny a Lozada-based motion to reopen based on a failure to file a bar complaint where the non-citizen, like in this case, submitted other evidence to satisfy Lozada's requirement that such motions include, quote, evidence that the aggrieved party filed a complaint with the appropriate disciplinary authorities, and if not, why not, end quote. That's Montufar Caballero et al. V. Garland, published by the 10th Circuit on January 15th, 2025, and it's worth remembering. And boy, oh boy, do I urge counsel, whoever and wherever you are, to move the 10th Circuit to make this decision precedential. Also, thanks for the heads up and effective assistance of counsel warrior, Rekha Sharma Crawford. New Attorney General next week. Sort of a passing of the torch or turning of the guards on the podcast. Soak up this last episode of hearing me say, Garland. Our first case is Ndungu, the Attorney General of the United States, published by the Third Circuit on January 13th, 2025. En banc, so the whole court. This is an exceptionally long en banc decision about crimes involving moral turpitude, or CIMTs. It also lays out the Third Circuit's categorical approach framework generally, and so, as an en banc decision, post-Loper Bright, it's pretty much ground zero for Third Circuit crimmigration. Note it. Mr. Ndungu is a lawful permanent resident from Kenya. He got that status because he won the visa lottery, the literal green card lottery. So congrats, Mr. Ndungu. Apparently won a $55,000 for fiscal year 2008, by the way. The more you know. All set for a new life in Lancaster County, Pennsylvania, and 21 years old. But 6 years later, and then 5 years after that, he pled nolo contendere to 2 separate charges of felony fleeing or attempting to elude law enforcement, and those each resulted in convictions under 75 Pennsylvania Consolidated Statute Section 3733 A.2.2. Also, in between those 2 convictions in December 2016, Mr. Ndungu was convicted of 2 related counts of simple assault in violation of 18 Pennsylvania Consolidated Statute, Section 2701, A1. DHS alleged that the fleeing law enforcement convictions both qualified as CIMTs, making them 2 or more CIMTs not arising out of a single scheme of criminal conduct that makes LPRs like Mr. Ndungu removable. The Third Circuit explains that apparently the concept of a CIMT at immigration law goes all the way back to, quote, the Immigration Act of 1891, where Congress excluded from admission to the United States persons who have been convicted of a felony or infamous crime or misdemeanor involving moral turpitude, end quote. And that is still a governing definition to this day. But what does it mean, en banc Third Circuit? That is, the CIMT definition. That's the central question here, because in order to know whether the fleeing law enforcement convictions meet it, you gotta know what a CIMT means. Well, to the Third Circuit, looking at a law review article from 1929, the court notes that the term, unlike most immigration terms, appears not to have a definition at common law. Nor is it really something you can do a state survey of for comparable crimes. And in any event, what time period would you even be doing your state survey on? The CIMT definition has changed over time. The Supreme Court mentioned fraud crimes in 1951 and instructed the lower courts to focus on the elements of the state offense rather than looking to the facts underlying conviction. So there's that. This is our baseline CIMT stuff. The Third Circuit quite quickly notes that its own precedent on the term has relied both on Chevron deference and deeper analyses, which I suppose the court means by implication makes their pre-Loper Bright CIMT precedent good law. Interesting way to do that. As such, in the Third Circuit, CIMT crimes require the following elements, quote, for the actus reus, the crime must involve reprehensible conduct, meaning an act that is inherently base, vile, or depraved, contrary to the accepted rules of morality and the duties owed to other persons, either individually or to society in general, end quote. For the mens rea, or mental state, the crime must be, quote, committed with a culpable mental state. Specific intent, deliberateness, or willfulness satisfies that requirement, as does recklessness, defined as a conscious disregard of substantial and unjustifiable risk that serious injury or death would follow, end quote. To be honest, none of that is particularly helpful to me, but it is our starting point. And as I mentioned, while there was a bit of back and forth, in this case, the ultimate removability charge depends on both of those Section 3733A22 convictions being CIMTs. And whether they are CIMTs and what the CIMT definition is so important to the Third Circuit that the court voted to go en banc after oral argument, before even the panel issued a decision. Something I would have loved to know before page 16 of the decision as I frantically searched my case summaries in an effort to figure out why I had missed this panel decision before. The first issue addressed by the court was actually res judicata. See, an immigration judge had terminated proceedings initially when DHS's removability charge relied on one of the fleeing convictions and one assault conviction, all before he got his second fleeing conviction. The IJ didn't believe that the assault conviction was a CIMT and so terminated proceedings. DHS re-NTA'd Mr. Ndungu after he got his second fleeing conviction in 2019 and alleged that both the earlier fleeing conviction previously adjudicated and the second fleeing conviction together constituted 2 or more CIMTs. The IJ and the BIA held that that was okay, that res judicata did not bar the second set of removal proceedings, and the Third Circuit agreed. Recall from law school, res judicata refers to claim preclusion, while collateral estoppel refers to issue preclusion. So the theory goes here that DHS's claim that Mr. Ndungu's 2014 flight can make him removable would be barred by res judicata. Collateral estoppel would in turn, hypothetically here, bar DHS from alleging that the assault conviction was a CIMT because the IJ literally already decided that issue on the merits. And as the Third Circuit explains, quote, Congress is presumed to have legislated with an expectation not merely that agencies could determine the preclusive effect that they would afford to their own orders in future administrative proceedings, but even more, that final agency orders would be presumed to have res judicata and collateral estoppel effects on later agency adjudications, end quote. No small holding from the en banc Third Circuit. Be that as it may, that res judicata and collateral estoppel can potentially apply. The Third Circuit also has in the past, quote, refused to bar subsequent removal charges against a non-citizen who commits later crimes, end quote. Because things changed after the IJ terminated proceedings here. Mr. Ndungu received another conviction, which in turn affected the relevance of his 2014 fleeing conviction. That's important because for res judicata to apply in the Third Circuit, there must exist 1, a final judgment on the merits in the prior suit, 2, a subsequent suit based on the same cause of action, and 3, involvement of the same parties or their privies in both suits. 1 and 3 definitely apply here, to me at least. Seems like actually the IJ and the BIA didn't believe number 1 was met for some reason that I don't understand. Seems like the Third Circuit isn't wild about that holding and focused on number 2. To the en banc court, the second prong requires analyses of, quote, the factual occurrence or conviction underlying the charge of removability, end quote. And well, the change in between the IJ's termination and DHS's recommencement of removal proceedings appears to be a new factual occurrence. DHS was by 2019 alleging at least 1 new fact, the new fleeing conviction. And IJ could not have ordered Mr. Ndungu removed in the future for the same allegations already terminated, fine, even if the law had changed. But what happened here is different. There was a new conviction. That it was combined with the 2014 fleeing conviction already kind of adjudicated alongside the assault thing is of no consequence to the court. So, res judicata does not bar the second set of proceedings. All of this analysis to decide whether Mr. Ndungu can even again be charged as removable. He can. But he's not, explained the Third Circuit. And that's mainly because, well, the IJ and the BIA misapplied the realistic probability test. They did it in a way that they want to because it results in more people being removed. It's the way that the Fifth Circuit applies it too, but it's not really the law anywhere else, and certainly not in the Third Circuit, explained the full en banc court. The categorical approach, of course, applies to the CIMT analysis, meaning, again, we focus on the elements of the offense and not the facts. But in 2007, the Supreme Court held in Duenas-Alvarez that even if those elements match, quote, a categorical mismatch is possible if there is a realistic probability, not a theoretical possibility, that the state would apply its statute to conduct that falls outside the generic definition of a crime, end quote. That is, a non-citizen can avoid removal by pointing to their case or another case to show that the actual conduct they were convicted of or someone else was convicted of was broader than the definition of the removable offense, notwithstanding what the textual elements appear to be. It's a way for non-citizens to avoid removal. That is the realistic probability test. It's a last way to save themselves in rare circumstances. It is not a way for the government to deport more people by requiring that non-citizens find an actual successful prosecution case that proves, yes indeed, the overbroad statutory text means what it says. Restated in the Third Circuit, the court has, quote, limited the realistic probability analysis to instances in which the elements of the state crime and the federal offense were identical, end quote. It's something that can only help, not hurt non-citizens. What the BIA did here was, essentially, identify conduct criminalized by the text of the statute, but then rejected it because the BIA didn't believe there was a realistic probability that Pennsylvania would actually prosecute such conduct. That's not how it works, said the full Third Circuit. This is a very long analysis, but it was a really long decision. So let's step back into traditional categorical approach analysis. Section 3733A generally makes criminal, quote, any driver of a motor vehicle who willfully fails or refuses to bring his vehicle to a stop or who otherwise flees or attempts to elude a pursuing police officer when given a visual and audible signal to bring the vehicle to a stop, end quote. It gets wonky, but to the Third Circuit, that describes means of committing one crime. It's not divisible, and it's not necessarily morally turpitudinous, right? Just failing to stop for a cop, even briefly? Now, there are misdemeanor and felony punishment versions of this offense, and the Third Circuit explains here that those are separate crimes. They're divisible. Makes sense, too, different punishments. And the highest court in Pennsylvania has determined that different elements must be proven at trial to get the different punishment. And as relevant here, the offense is a third-degree felony under subsection A2(2). And that applies if the driver is fleeing or attempting to elude a police officer, and it either relates to a DUI, crosses state lines, or endangers law enforcement or the general public due to being a high-speed chase. That's really the crime at issue here. I bet you it's going to come down to that state line thing. Now, fortunately for Mr. Ndungu, quote, in context, the term fleeing is best understood to encompass all forms of fleeing, including failing or refusing to stop a vehicle. That's all the stuff criminalized by the general statute. That means essentially that the least culpable conduct criminalized by the third-degree felony statute of conviction here is, I suppose, failing to stop for a cop by drifting very slowly from Pennsylvania into Ohio, I suppose. The Third Circuit here did find the 3 third-degree felony enhancements elements of the offense, and the IJ held that fleeing or attempting to flee while endangering law enforcement or the general public in a high-speed chase is a CIMT, because that's what the records show Mr. Ndungu did in 2014. The Third Circuit also notes that in 2019, he was apparently 30 miles from a state line, so unlikely that he just drifted into a different state. But in that later 2019 offense, the state court did not identify the subsection of enhancement. So it could have been the state line thing, technically, right? As just an aside in a very, very long case, but as I so often mention, doesn't the fact that the conviction documents don't show a specific subsection of enhancement for 2019 give lie to the whole elements analysis? If the subsection is an element, as the Third Circuit says, because conviction requires identification of the subsection, but the state court didn't identify a subsection, aren't we admitting that either the conviction is invalid or that in practice criminal courts in no way work the way the categorical approach assumes they do? But I digress. Without knowing the subsection of Mr. Ndungu's 2019 offense, it can only be a CIMT if all 3 ways of getting the third-degree felony are. But they're not, explained the Third Circuit. And wouldn't you know it, it's not the state line thing. It's the high-speed eluding. Who knew? The Third Circuit. Yes, generally, fleeing from the police at a high speed makes everything dangerous, and it is morally turpitudinous. But under the statute, like so many Pennsylvania crimes, due to an apparent, quote, gap-filling statute, end quote, this crime can be committed via a reckless mens rea. The Third Circuit reads that to mean that the conviction, quote, includes recklessly fleeing or attempting to elude a law enforcement officer based on a good faith belief in the need for emergency medical care, end quote. To be honest, I'm not sure how the court got to the medical care stuff. Maybe it was just an intelligent hypothetical based on the text? If so, whoa. And well done, counsels. Because after everything I just said, that's what won the day. The unclear 2019 eluding conviction isn't a CIMT, meaning Mr. Ndungu isn't removable for having been convicted of 2 or more CIMTs. And honestly, I guess the 2014 conviction isn't a CIMT either. I'm exhausted. With all that work, lots of congratulations are in order. Congratulations, Andrew Mahone, Christopher R. Healy, and Caitlin L. O'Donnell, who argued it before the Third Circuit at different times, and they're with Wilmer Hale. Congratulations to Ayla McDermott, the National Association of Criminal Defense Lawyers, Immigrants Defense Project, Heartland Alliance's National Immigrant Justice Center, Immigrant Justice, and the National Immigration Project of the National Lawyers Guild, along with Nationalities Service Center, All Rise Trial and Appellate, and of course, the roundtable of former IJs and BIA members who all got involved on amicus. Did I miss anyone? Probably. Everyone seems to have been involved. Don't worry, everybody. None of the other decisions this week are nearly that long. But that was Ndungu v. Attorney General of the United States in banc. Next is matter of Arciniegas-Patino, published by the BIA. It's the last decision of Attorney General Garland's BIA, published, you know it, on a Friday. Literally, the last day possible. Let's get out in front of this right now, BIA. During the first Trump administration, there seemed to be a noticeable pattern of the BIA, you, publishing on Friday afternoons, often in decisions that were not so great for non-citizens. Honestly, the substance is what it is, and it's your prerogative. But my goodness, BIA, can you consider providing us with your wisdom on a day that is not Friday for the next 4 years? For my own mental health and workload? Consider this a negotiation, and truly, this is all I ask. The ball's in your court. But man, Tuesdays, for example, are amazing days to publish. Many people are saying it. The Supreme Court largely publishes on Wednesdays, just saying. Let's begin. This case is about procedure and complying with briefing schedules. As all removal defense practitioners know, EOIR has been transitioning to an electronic case management system for a few years now. Eventually, there will no longer be paper cases, and I, for one, celebrate it. Federal courts and most state courts have operated in this way for years, if not decades. Immigration court finally caught up. But with electronic filing and noticing come electronic potential problems. The respondents here are from Colombia and were placed in removal proceedings that were placed in the electronic EOIR ECAS system. The respondents, through counsel, submitted documents electronically through ECAS. An immigration judge eventually denied their claims and ordered them removed, meaning that the order was served electronically too, I suppose. Rather than file an electronic notice of appeal, the respondents filed paper notices through the same counsel. I'm not sure why here, but admittingly it was a bit confusing to me at first, that is, filing E26 notices of appeal electronically. I even had to correct a mistake I made about that on the podcast last year, if you recall. But then again, I think the process for filing electronic EOIR 26s is a bit more straightforward, where, like here, the attorney who represented the non-citizen below in immigration court is also appealing to the BIA, too. In any case, the BIA accepted this paper notice of appeal, noticed as much electronically, and then sent a paper notice for good measure. Then on July 29, 2023, the BIA set a briefing schedule. That briefing schedule was issued electronically in the ECAS system. The respondents didn't meet their deadline, didn't file a brief, and so the BIA summarily dismissed the appeal. The respondents, or likely counsel, received the electronic BIA order dismissing the appeal, and timely moved to reconsider, attesting that, quote, they did not receive notice that their appeal had become an electronic record of proceedings, and were expecting that the briefing schedule would be issued in paper form, end quote. The BIA was not swayed. Under the regulations, quote, filing through ECAS became mandatory for all attorneys and accredited representatives with limited exceptions not relevant to the instant case, end quote, on February 11th, 2022. Assuming you have an electronic case, that is. There are some old immigration court and BIA cases that started out paper before that date, and my understanding is that generally, once paper, always paper. Check me on it, but I'm rarely wrong. Also, IJs and the BIA retain discretion to accept paper filings under the regulations. Also, my understanding is that even a paper immigration court case, which wasn't the case here, becomes an electronic ECAS appeal if appealed after February 11, 2022, which of course is all appeals going forward. So, when you sign up for ECAS, you provide an email, and that email is supposed to receive a notice when anything happens in ECAS. Almost always does, but I'm not going to lie, BIA, I'm pretty sure that things have happened to me in ECAS where I did not receive an email about it, at least in the past. Under the regulations, though, quote, EOIR will consider service completed when the electronic notification is delivered to the last email address on file provided by the user, end quote. Here, in addition to stating that they expected that this would all happen over paper, the Respondents' Counsel asserted that, quote, notice of the briefing schedule was delivered to their counsel's spam folder and was not seen until after the BIA dismissed the appeal, end quote. Nightmare. And no forgiveness, reasoned the BIA, at least under these circumstances. This has always been an electronic case. The same firm represented the respondents before the IJ and the BIA, and that firm previously submitted documents electronically. Nor does the BIA's acceptance of the notice of appeal in paper form create an exception to the electronic filing requirement. The BIA has the discretion to accept, after all, and to be honest, I'm glad they do. But, quote, neither the acceptance of the paper notice of appeal nor providing a courtesy paper copy of the receipt notice creates a future expectation that electronic notice will not be utilized. It also does not relieve counsel of the obligation to actively monitor the inbox, including the spam folder or the email address on record with EOIR, end quote. The BIA appears to indicate that more details about what counsel did to try to make sure they didn't miss notice via email might have helped. However, the BIA also states that, quote, where parties were properly served with electronic notice of the briefing schedule, a representative's failure to diligently monitor the inbox, including the spam folder of the email address of record, does not excuse a party's failure to comply with briefing deadlines, end quote. Getting a bit philosophical, the BIA concludes that, quote, in this electronic world, an attorney's obligation to monitor, check, and open emails is no different than their obligation to go to the mailbox, retrieve their paper mail, open it, and act upon it, end quote. Suppose that's true. All of it means, however, that the non-citizen respondents remain ordered removed without getting their appellate arguments heard, and counsel is surely devastated. And might I just add, having clerked for a federal judge after my 2-year attorney advisor position with EOIR, I can tell you that missed briefing deadlines such as this are often forgiven in federal court, particularly when timely motioned. Judges aren't required to. Missing deadlines is serious stuff, and all judges are different. But technical mishaps, specifically, are often forgiven, maybe given the difference in tech savviness throughout the different generations of lawyers. In my experience, at least, there is a real feeling among many federal district court judges that parties shouldn't win or lose based on technicalities if substantive arguments have been made, even a bit untimely. The BIA's decision here could be read as telling IJs never to excuse attorney deadline mistakes on ECAS. And if so, well, that seems quite harsh, particularly with lives rather than money on the line, and it just isn't how civil or criminal courts operate. Food for thought. And that is matter of Arciniegas-Patino. Moving right along, the Vargas Panchi v. Garland, published by the First Circuit on January 13, 2025. This case is about asylum. And it's about Mr. Vargas Panchi, his wife, and their 2 children, who are all from Ecuador and entered the United States in 2021. They brought asylum claims and removal proceedings based primarily on Mr. Vargas Panchi's membership in the asserted particular social group and race of, quote, indigenous Ecuadorian men, end quote. He and other witnesses testified. Mr. Vargas Panchi and his witnesses testified to a lot of discrimination as they traveled the country to sell potatoes, with his children also being called names and being discriminated against in school. Mr. Vargas Panchi testified that he was once hit over the head with a beer bottle by members of a, quote, mostly mestizo soccer team, who initiated a brawl after losing to his mostly indigenous soccer team, end quote. As the First Circuit notes in a footnote, mestizo refers to mixed race, and his assailants threatened to kill his entire family. Then again, Mr. Vargas Panchi testified that the fight mostly happened because his team won the soccer game. Mr. Vargas Panchi testified that he was denied treatment at a public hospital because he is indigenous, and that he was specifically told this by the hospital staff. He spent 2 days in the hospital waiting room and then got 18 stitches in his head at a private clinic, staying there for 6 weeks. The hospital refused to treat him. Mr. Vargas Panchi didn't testify to other harms, but explained how his parents and siblings were discriminated against to this day in Ecuador, quote, when they go to the city, end quote. An immigration judge denied for many reasons, including based on a no nexus finding and believing that in any event, Mr. Vargas Panchi's fears of future persecution were not objectively reasonable. The BIA affirmed, as did the First Circuit. It agreed that race or being indigenous, whether race or particular social group I suppose, was not one central reason for that soccer fight. Mr. Vargas Panchi said as much in his own testimony. The court explained. Not even a mixed motive, explained the First Circuit. Yes, there was circumstantial evidence that race played a serious role in the attack, both from the attack and Mr. Vargas Panchi's experiences before it, but it wasn't compelled by the record, explained the court. The evidence wasn't so overwhelming as to require reversal of the agency. True. There is some dicta from the BIA's 1996 decision matter of Fuentes that indicates that the nexus analysis should focus on whether the applicant reasonably regarded that the harm was on account of his race. But in the First Circuit, that case is more about well-founded fear than past persecution, and in any event, the court believes that that 30-year-old BIA quote and some First Circuit precedent discussing it are a bit incomplete. Quote, a petitioner's belief, whether reasonable or not, is not determinative of a finding that past persecution was on account of a protected ground, end quote. Still evidence, though, I imagine. Well, what about that hospital thing, though? A public hospital refused to treat his serious head injury because he was indigenous. Quote, certainly the intentional denial of medical care on account of race is abhorrent, and certainly it could rise to the level of persecution in the right circumstances, end quote. Go on. Or don't, because again, the court relies on standards of review and doesn't see the record as so overwhelming as to overturn the IJ and the BIA here. Mr. Vargas Panchi didn't testify to increased injury or pain, despite the 2-day wait, for example. Quote, without any evidence in the record about the level of severity of the harm caused by the denial of care, we cannot say that the BIA was compelled to conclude that the denial of medical care rose to the level of persecution, end quote. Meh, I say, First Circuit. But all of this meant that the court wasn't going to overturn the past persecution claim, meaning that Mr. Vargas Panchi had the burden to show that he had a well-founded fear of future persecution, and well, he didn't do so sufficiently, said the court. Not only did Mr. Vargas Panchi have nexus problems before, but the First Circuit didn't believe there a reasonable possibility that the soccer attack and denial of medical care would happen again. As to the discrimination he and his family have experienced in the past, well, discrimination isn't persecution. Nor does the First Circuit see a pattern or practice of persecution against indigenous individuals in Ecuador, an alternative way to get asylum when the specific facts of a non-citizen's claim don't cut it. And it's because it's a high burden. Non-citizens must show, quote, systemic persecution, end quote, of the group, race, etc., to succeed on a pattern or practice claim. In this case, here too, discrimination, even if widespread, is insufficient. Meaning, Mr. Vargas Panchi and his family lost their case. And that is Vargas Panchi v. Garland. Sticking with asylum, we have Mateo-Esteban v. Garland, published by the Sixth Circuit on January 13th, 2025. This case is mostly about particular social groups. Mr. Mateo-Esteban is from Guatemala. So is his father, and they entered the United States together in 2015 when Mr. Mateo-Esteban was 5 years old. So I guess he's 14 or 15 today? DHS initiated removal proceedings against Mr. Mateo-Esteban and reinstated a final order of removal against his father, as the father had been physically removed the year before. Mr. Mateo-Esteban didn't appear for his hearing. Remember, he was 5 years old, and an IJ ordered him removed in absentia. Council moved to reopen 3 weeks later, which an IJ refused to do for this 5-year-old, but the BIA eventually reopened proceedings. In those reopened proceedings before an immigration judge, Mr. Mateo-Esteban applied for asylum and related relief. The father, who had that final order reinstated, was permitted to stay in the United States while his son litigated his asylum claim. And the father testified at the merits hearing 3 years later. Essentially, gangs in Guatemala threatened to take Mr. Mateo-Esteban, the son, if his father, who worked at a fruit and vegetable market, didn't pay extortion. The father didn't report any of it based on a belief that police work with the gangs in Guatemala. The IJ denied. Unsure if this is actually the group proffered, but the IJ found the proposed social group of, quote, people who are afraid of gangs in Guatemala, end quote, not to be a particular social group, because quite frankly, it's not under BIA precedent. Plus, the IJ thought that the father wasn't credible and that Mr. Mateo-Esteban, the child, could reasonably relocate in Guatemala, at least, for example, to go live with his mother. Convention Against Torture Protection denied too, the BIA affirmed. As did the Sixth Circuit. Recall, in the Sixth Circuit, as with everywhere really, to prove membership in a legally cognizable social group, the petitioner must show that his proposed group, 1, shares a common, immutable characteristic other than the fact that it is targeted for persecution, 2, is particular and defined with sufficient precision to delimit its membership, and 3, is socially distinct, such that members of the group are perceived as a group by society. Under how the BIA interprets the exceptionally ambiguous particular social group phrase, anyway. And yes, indeed, Mr. Mateo-Esteban first argued through counsel that he never asserted that particular social group that isn't cognizable. He asserted that he claimed to fear persecution on account of his membership in the group, quote, minors threatened to be kidnapped by gangs in Guatemala, end quote. Not saying that's cognizable either, but it's definitely better than that first group. The problem is that the Sixth Circuit is that his counsel before the IJ did indeed assert the group people afraid of gangs, and no other group. Mr. Mateo-Esteban asserted this new group to the BIA on appeal, but the BIA's 2018 decision matter of WYC and HOB permits the BIA to ignore particular social groups asserted for the first time on appeal. The Sixth Circuit doesn't come right out and say it, but it seems to believe WYC and HOB A-OK. Although I do seem to recall some recent circuit precedent, casting a bit of doubt on that BIA decision. Check the podcast page. Anyway, that left only cat protection because you don't have a viable particular social group, but the Sixth Circuit affirmed denial of that, too. Here it was on the government acquiescence, consent, or willful blindness prong, something discussed extensively and in very interesting detail in that First Circuit decision last week. To the Sixth Circuit, acquiescence, quote, requires that the public official know of the torture prior to its occurrence and thereafter breach his or her legal responsibility to intervene to prevent such activity, end quote. Mr. Mateo-Esteban had a problem here too because apparently counsel failed to submit country condition evidence at the immigration court hearing. So that's a big problem. In any event, a quite bit more narrow than the discussion out of the First Circuit last week, quote, when a country has made meaningful efforts to control private violence but is still struggling to gain the upper hand, we generally do not say that public officials have acquiesced, end quote. Moreover, and apparently in the Sixth Circuit, quote, we usually treat a failure to inform authorities as a signal that the government did not turn a willfully blind eye to the applicant, end quote. That said, something to remember in the Sixth Circuit, quote, while a failure to report is important in our analysis, it is not dispositive, end quote. Here, though, there was no actual proof for the father's claim that police work with the gangs and so that police couldn't be counted on. Reason the court. At least where, again, here the non-citizens didn't really submit evidence. And the other evidence of record, quote, shows that the government is taking steps to combat corruption, end quote. All of it meant that Mr. Mateo-Esteban, a child in the middle of all of this, lost his case and very well may be removed from the United States soon. And that is Mateo-Esteban v. Garland. Next is Godoy Aguilar v. Garland, published by the Ninth Circuit on January 13th, 2025. This case is about obstruction of justice aggravated felonies and follows pretty directly from the Supreme Court's Pugin decision 2 terms ago, episode 165. Hope you didn't get burnt out on the categorical approach from that first case this week, because we're doing it again. Mr. Godoy Aguilar is a lawful permanent resident from El Salvador, but later pled nolo contendere to a violation of California Penal Code Section 136.1c1. That statute criminalizes, quote, dissuading a witness by force or threat, end quote. He received a sentence to 1 year in jail. DHS initiated removal proceedings alleging that the conviction was an aggravated felony, as defined at I&A Section 101A43S, an offense relating to obstruction of justice. Up until relatively recently, DHS was probably wrong under Ninth Circuit precedent, because the offense permits conviction for dissuasion of cooperation with police when police aren't even investigating a crime yet. And IG and the BIA nevertheless found Mr. Godoy Aguilar removable. Here, the Ninth Circuit affirmed that removability finding. Because, of course, after Puget, to match the federal generic definition of relating to obstruction of justice, quote, no pending investigation or proceeding is required, end quote. And I mean, the Ninth Circuit already held as much in the Puget companion case remanded to the Ninth Circuit regarding the next door subsection at issue here, subsection B, in Cordero Garcia v. Garland, episode 218. Specifically here, section 136.1c1 applies when someone commits a section 136.1a or b offense by use of threat or force. Turning then to the first of those underlying offenses, Penal Code Section 136.1a1 makes it an offense to knowingly and maliciously prevent or dissuade any witness or victim from attending or giving testimony at trial, proceeding, or inquiry authorized by law. To the Ninth Circuit in Puget, the Supreme Court listed as an example of the conduct covered by obstruction of justice, influencing or impeding a witness or potential witness. Such acts are clearly covered by Section 136.1a1, explained the Ninth Circuit, and so they satisfy the categorical approach. There are other underlying subsections here, though, and the Ninth Circuit goes through all of them. But Cordero Garcia rejected some of the other arguments about the overbreadth of these very substatutes, including, for example, that the mental state required of them is less than the federal generic definition. It's not, reiterated the Ninth Circuit. Nor does it matter, explains the panel, that subsection A2 covers mere attempts because the generic federal definition of obstruction of justice covers attempts too. Nor does it matter that subsection B2 applies when, for example, the defendant attempts to prevent or dissuade someone from filing a criminal complaint or doing related things, or that subsection B3 applies when the defendant attempts to prevent an arrest. Quote, complaints, indictments, informations, probation violations, and parole violations are clearly legal proceedings, end quote, and so are covered by the generic federal definition of obstruction of justice. Attempting to prevent an arrest is covered too, explains the court. Restated, pretty much the entirety of Cal Penal Code Section 136.1 appears to match the federal generic definition of obstruction of justice now. And because Mr. Godoy Aguilar was sentenced to at least 1 year in prison, it makes his conviction an aggravated felony. Don't forget that Section 101A43S is one of the few aggravated felonies that is tethered to a 1-year term of imprisonment. If, for example, you're trying to save your lawful permanent resident client at sentencing. Mr. Godoy Aguilar, however, lost his case. And that is Godoy Aguilar v. Garland. Meaning we conclude with Santos Zachariah v. Garland, published by the Fifth Circuit on January 13th, 2025. Gotta end with a win, right? Remember this one? Of course you do. It was remanded by the Supreme Court 2 years ago, episode 159. Back then, the issue was whether the Fifth Circuit could even review the case, given the Fifth Circuit's weird requirement that non-citizen litigants needed to move the BIA to reconsider its findings when the BIA makes a mistake before petitioning for review. The Supreme Court said that rule made absolutely no sense, and so the Fifth Circuit panel has now reviewed this matter on the merits. And wouldn't you know it, it determined that the BIA erred and remanded itself. Miss Santos Zachariah is a transgender woman from Guatemala, attracted to men. She testified that she was raped by a neighbor in Guatemala when she was only 12 years old, for being gay. The IG and the BIA denied her claims for withholding of removal and Convention Against Torture Protection. Unstated why asylum was off the table here, but a past persecution showing, if made, will provide a non-citizen with a rebuttable presumption of a well-founded fear of future persecution for withholding of removal, just like it will for asylum. Anyway, the Fifth Circuit sent it back, as I mentioned. First, it held that the BIA engaged in improper fact-finding. The BIA isn't allowed to find facts on appeal under its own regulations. It is a reviewing appellate body. See here, the IJ had held that rape was not bad enough to constitute past persecution. The BIA, understandably wanting to avoid that finding like the plague, but still not seeing a claim, held that rape was and is past persecution, and that here it was on account of a cognizable protected ground, but that DHS had met its burden to establish that conditions had changed. Ms. Santos-Zaccaria was no longer a child anymore. The rape occurred 18 years ago, and she did not even know where in Guatemala her attacker now lived, reasoned the BIA. Plus, homosexuality is apparently not a crime in Guatemala. The problem, said the Fifth Circuit, is that the IJ didn't hold any of that. The BIA did. And it's not allowed to do that under its own regulations. Oil tried to save this clear error by arguing that whether DHS has met its burden to rebut a well-founded fear of future persecution for withholding of removal purposes is, I guess, a mixed question of law and fact, making it a legal question that maybe the BIA can kinda hold on its own? I suppose that's the argument. But the Fifth Circuit rejected it, because at a minimum, some of the facts the BIA relied on were disputed before the IJ, including, for example, whether Ms. Santos-Zaccaria could change her gender under Guatemalan law. Similarly, quote, whether she could safely move elsewhere in Guatemala was one of the most hotly contested issues in her proceeding, end quote. So the BIA wasn't just applying agreed facts to a legal standard, it was making factual decisions, and it can't do that. Mixed questions of law and fact are all the rage now in these cases, so take note when the Fifth Circuit explains what that means. Quote, a question is considered to be a mixed question of law and fact when the historical facts are admitted or established, the rule of law is undisputed, and the issue is whether the facts satisfy the statutory standard, end quote. Not the case here. Recall, the facts were disputed below before the IJ. By the way, in the BIA's defense on the merits, it flat out came out and made clear later that rape is past persecution, matter of HCRC, episode 217, if it's on account of a protected ground. I can only imagine it had Ms. Santos-Zaccaria partially in mind when it made that holding. Moving back then to the BIA's errors. Gleaned once the Fifth Circuit reviewed the issue. The BIA also failed to correctly address Ms. Santos-Zaccaria's claim that there exists a pattern or practice of persecution against transgender women in Guatemala. That's an alternative path to asylum or withholding of removal and must be analyzed. Even if the past persecution thing doesn't win the day, pattern or practice claims can get a non-citizen asylum or withholding of removal, explained the court. The Fifth Circuit concluded by holding that the cat denial was sufficient and need not be done again, which quite frankly it held the first time around in this case, so really probably couldn't hold otherwise now. But it's a big win and a big remand for Ms. Santos-Zaccaria, who continues to make good law for non-citizens at the highest levels. Meaning. Big congrats to Benjamin Osario again, as well as the heavy hitters Paul Hughes and Sarah Hogarth from McDermott. Back-to-back week wins for Benjamin. Word up. And that is Santos-Zaccaria v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/immigrationreview or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.